What happens when a federal judge smirked seconds before getting blindsided by the very lawyer he just underestimated? The federal courthouse in San Francisco buzzed with an unusual tension that morning. Every seat in Courtroom 7A was filled. Law students, reporters, and legal analysts packed shoulder to shoulder, waiting for what was expected to be a routine decision in a controversial case. But routine was not the word anyone would end up using. At precisely 10:03 a.m., the tall double doors swung open and Pam Bondi rose from the defense table. Dressed in a navy blue suit with her signature calm presence, she gathered her notes and stepped forward. All eyes followed her movement. On the bench above, Judge Paul Engelmayer, authoritative figure with salt and pepper hair and a reputation for procedural rigor, leaned back slightly in his chair. He glanced briefly at Bondi, then murmured, not quite under his breath, but not loudly enough for the room, "Let's see how the Florida firebrand spins this one." The clerk froze. A few heads turned, but it was the courtroom central microphone always live that captured the remark in full clarity. It didn't take long for a clip of that moment to hit Twitter. Within an hour, legal Twitter would light up. But in that room, in that moment, no one said a word. Bondi didn't flinch. She didn't react. Instead, she adjusted her glasses, looked directly at Judge Engelmayer, and said, "Your Honor, I appreciate the opportunity to address the court before a final ruling is issued. I'll be brief, but there are 3 critical facts that have surfaced since our last session." There was no shake in her voice, no hesitation, just clarity. To the casual observer, this might have seemed like another day in administrative law, but to those in the room who had followed the case closely, it was clear something unusual was about to happen. The case was about Health Link Directive 14A, a newly enacted federal regulation mandating the cross-state sharing of patient medical data. The government said it was essential to modern healthcare coordination. Critics, Bondi chief among them, argued that it was an unconstitutional overreach, a violation of both the Fourth Amendment and state sovereignty. Most legal analysts believed the case was all but lost for Bondi. The legal precedents weren't in her favor, and Judge Engelmayer, who had repeatedly shown skepticism toward her arguments in prior hearings, seemed poised to dismiss the challenge outright. The temperature in the courtroom felt colder than the air conditioning. Bondi opened her leather briefcase and retrieved a folder. Unlike the piles of annotated documents she'd worked with earlier in the trial, this one was slim. 3 sheets of paper, clipped neatly, but it wasn't the paper that drew attention. It was the expression on her face. She looked not like a lawyer about to argue, but like someone holding a card no one else at the table had seen. Judge Engelmayer raised an eyebrow. "I'd like to submit 3 exhibits, each of which directly addresses the constitutional and procedural claims raised in the department's filings," she said. The courtroom remained still, but something had shifted. Even Clark Redmond, the government's lead counsel, leaned forward slightly, lips tightening. Judge Engelmayer saided, "Miss Bondi, the administrative record closed months ago. You know that." Bondi nodded. "I do, and I also know that none of these documents were available at that time. One was obtained through a Freedom of Information Act request. The others were provided by a whistleblower within the Department of Health." That last phrase landed like a drop gavel. The reporters in the gallery straightened in unison. Even the judge blinked twice. Bondi took a step toward the clerk and handed over the first document. "This, Your Honor, is a full schedule of the department's so-called stakeholder consultations. It shows every meeting occurred after Directive 14A was finalized. These were not consultations. They were briefings." Judge Engelmayer flipped through the pages with visible disinterest at first, but something on page 3 made his brow furrow. Bondi didn't stop. "My second exhibit," she continued, "is an internal memo from a senior legal advisor at the department. It acknowledged explicitly that the directive likely exceeds the agency's statutory authority. That warning was ignored." She passed it to the clerk. Judge Engelmayer didn't speak. And finally Bondi said, retrieving the third paper, a series of internal emails. In one of them, a department staffer writes, and I quote, "Judges will rubber stamp it. They always do." The room went completely still. Judge Engelmayer's jaw tightened. Clark Redmond stood halfway up, then sat back down. No one had expected this, especially not the judge who had smirked just 5 minutes earlier. Pam Bondi returned to the podium, calm and composed, as if she hadn't just lobbed a grenade into the heart of the government's case. "For the record, Your Honor," she said, "I'm not here to make this personal, but the Constitution does not grant any agency the right to exceed the authority given by Congress, least of all, while counting on judicial deference to escape scrutiny." She paused, letting the silence stretch. "Thank you." And then she stepped back. In the next 17 minutes, legal history would change. But in that moment, no one, not the government's attorneys, not the judge, and certainly not the reporters watching, knew what was coming. The only person who seemed entirely certain was the woman they'd underestimated. Judge Paul Engelmayer didn't speak. As Pam Bondi returned to her seat, his expression, once laced with condescension, was now unreadable. He adjusted his glasses and glanced toward his clerk without a word. On the surface, he maintained the stoicism expected of a federal judge. But beneath it, something had cracked. To understand why this moment hit so hard, you'd have to go back decades before the robe, before the bench, back to the Fireforge days when Palmier was a federal prosecutor in Denver. Engelmayer was once known as the ICE barrister. Colleagues described him as meticulous, blunt, and devastatingly efficient. He had no patience for emotional pleas or philosophical detours. For him, the law was a machine, and he was its most loyal operator. By the time he was appointed to the federal bench in San Francisco, his reputation had already solidified. He ran a non-nonsense courtroom, precision over passion, structure over spectacle. And if there was one thing he loathed, it was what he called legal theater lawyers who grandstanded, who used emotion to disguise weak arguments. That's what he thought Pam Bondi was when her name first appeared on the docket. Another political figure turned litigator trying to drag drama into his carefully controlled courtroom. He had seen her kind before, or so he thought. In the earlier hearings, he barely concealed his disdain. He interrupted her often, allowed opposing counsel longer windows to speak, and routinely dismissed her supplemental filings with curt remarks. "Theoretical, Miss Bondi," he'd said more than once. "This court deals in reality." But what Engelmayer failed to realize, what he was now beginning to understand, was that Pam Bondi was no showboater. She was a strategist, a former state attorney general with thousands of cases under her belt. She had once argued before the U.S. Supreme Court without flinching. Her courtroom presence wasn't built on flair, it was built on fact, and it wasn't only her credentials that brought her to San Francisco, it was something far more personal. A year earlier, Bondi had received a call from her younger cousin, Dr. Rachel Haskins, a psychiatric resident at a regional hospital in Salt Lake City. Rachel sounded shaken. Her voice trembled as she explained that she had refused to upload a patient's full psychiatric records into the National Health Link system without consent. The patient, a 19-year-old survivor of abuse, had begged for privacy. But under Directive 14A, Rachel had no legal standing to protect that patient. Within 2 weeks, she was suspended. Within 2 months, her residency was terminated. Pam had listened in silence. Then she asked for the names of the administrators, the documents they cited, and the federal codes they referenced. That night, she didn't sleep. By dawn, she had already begun drafting the legal challenge that would lead her straight into Judge Angela's courtroom. Health Link Directive 14A was framed as a federal efficiency measure, a streamlined system to ensure medical data flowed easily across state lines and emergencies. But in execution, it was something far more invasive. It allowed federal access to private health information without consent, bypassing traditional safeguards like court orders or patient release forms.